governance required for achieving multiple outcomes at landscape scale on commons. It is fantastic to have so many people signed up for our webinar tonight, with a mixture of regular attendees and some new people joining us. The Foundation for Common Land's charitable purpose is both to conserve the cultural landscapes associated with commoning and enhance the natural assets of common land for the benefit of the public. If you haven't visited already, please have a look at our website, which has a growing bank of resources in the Common Land Toolkit to support commons through the transition from CAP to ELMS. There are lots of other really interesting resources about our other projects as well there, so well worth the visit. Whilst I'm talking, please can you complete the poll to let us know who you are and introduce yourself in the chat. I can see lots of people have joined and introduced themselves, which is always really interesting. Tonight we'll be sharing our findings from phase 2 of our test and trial. And the question we're answering is, how can we achieve multiple outcomes at landscape scale on commons? So we have, I think this is one of 3 FCL tests and trials. In phase 1, we looked at how to incentivise land manager participation in landscape recovery schemes. And we've used the Malvern Hills and the New Forest as our case studies. In phase 2, we've looked at the practicalities and legalities of how to construct agreements on lowland commons. Commons property rights are split between a range of parties, most notably the owners and commoners. In addition, the public have a statutory right of open access on many areas of common land. Delivering landscape scale recovery will require all property and statutory rights to be respected, governed and managed. While we have 30 years of experience of Commons Agri-Environment Scheme agreements, landscape recovery, being longer term and more ambitious, requires a refreshed approach to constructing agreements that deliver the agreed outcomes and take account of multiple stackable funding streams, including private finance. Tonight we will have a general update from Julia Aglionby about ELMS following the recent announcement from Defra and the implications of these on commons, followed by a presentation from Josie of Michelmores in Bristol, who we've worked with in the test and trial to explore the options for the governance of landscape scale schemes on commons. Joseph Leeper and Susan Mitchell, our local facilitators, will then give a short update on the key findings of our Lowland Common test and trial and introduce the next phase of our work. During the webinar, please use the chat to discuss any key points. Please can you put any questions into the Q&A, as the questions can get lost in the chat, although we'll be watching closely and we might prompt you to put your question into the Q&A. You can also upvote questions that you would particularly like to know the answer to. At the end of the session, we'll have a Q&A with Julia and Josie, and we'll do our best to answer as many questions as possible, but we really do like to finish at 9 o'clock so everyone can have their evening. So any questions that we aren't able to answer in the chat or live, we'll try and answer after the webinar, and you're always welcome to email us with any questions or thoughts that you have after the webinar. We will be recording the webinar and it will be available to view on YouTube. You can also watch previous webinars and the webinars from our other tests and trials, and there's a link on our website, which is foundationforcommonland.org.uk. Susie, if you end the poll, we can see who we've got. So it's really interesting tonight. We've got a really high percentage of farmers attending, which is fantastic, 41%, and a range of others as well, which is really fantastic. I'll hand over to Julia Aglionby, who's our Chief Executive for the Foundation for Common Land.
Good evening, everybody, and lovely to be with you here this evening. For those who don't know you, my name's Julia Aglionby, and I'm part of the small team at the Foundation for Common Land, and we're absolutely delighted to have had so many sign up. We have 138 people present today, and other people who've asked for the recording afterwards. So please do remember, you will be sent a link to the recording, and you can share that with other people. It'll be available permanently on YouTube. So there's been an awful lot going on in the last week, and so we're very keen to share some of that with you. So we're I'm just going to say, so we've had just make sure that you can see the slides here. Great. So hopefully you can see that available there. Can make sure that. Excellent, that's better. Sorry for the delay there. So last week and this week, we've had two of the biggest announcements in the last 6 years since the decision was taken to leave the European Union. You may remember 5 years ago there was Health and Harmony, and we also had the 25-year environment plan. But in the last week, we've had both a policy paper on environmental land management, how the government will pay for land-based environment and climate goods and services, and also today, hot off the press, is the Environmental Improvement Plan 2023. So this is the first revision of the 25-year environment plan. So there's an awful lot going on at the moment. Both are very long documents, but I do recommend that you look on gov.uk for them and have a read. I'm particularly going to focus on what's called the ELM prospectus. So this is the first document. So this is the update from Defra about environmental land management. But there is some very relevant information on the policy paper, the Environmental Improvement Plan, that was released as well. So and you can think about the Environment Improvement Plan as the second document that's released today is really about the targets that the government is trying to achieve, and environmental land management is the mechanism by which Defra is seeking to achieve those on our farmland in particular, but also on woodlands. So you may have remembered that in the past, the ELM was always going to be a sort of 3-tier scheme. We've still got 3 tiers, but they're now called the Sustainable Farming Incentive. And then we've got the Countryside Stewardship Scheme is being retained. And then we also have Landscape Recovery. So at the Foundation for Common Land, we don't really care about the name on the tin. What we're really interested in what's going to be delivered and how easy it is to access these schemes. So we welcomed the use of the existing scheme, the Countryside Stewardship Scheme. That there will be continuity between the current and the future schemes. But what we're really interested in is the content of these schemes. And while it's fantastic to have the clarity that we've had last week, we still feel there's quite a long way to go to ensure that Commons will deliver as much as they can, that commoners and the owners of common land will be properly rewarded for the public benefits they deliver for society. So in terms of the Sustainable Farming Incentive, that's a sort of baseline scheme. It is available on Commons, which is good. All 3 schemes are available on Commons. And the big shift is I'm sure most of you know, for public money for environmental goods and services. We used to say public money for public goods, then I talk about public money for environmental goods and services, being really clear what exactly the government are paying for. As I say, it's a 101-page document. It's on gov.uk. If you do a web search for ELM update Defra, you'll find it there. So turning first to the sustainable farming incentive. In the past, some of you may have joined our webinar when we were talking about SFI on moorland, and that introductory standard on moorland remains. But the new standard, there were 6 new standards that were released last Thursday, but the one of particular interest for commons is low input grassland. So moorland is for the land above the moorland line, and low input grassland standard is for land below the moorland line. It may be in the lowlands or it may be in severely disadvantaged area, and there are effectively the same standard is available for both these areas of land. The payment rate in the lowlands is £151 a hectare, and it's £98 a hectare in the uplands, and these reflect the options under countryside stewardship, which are GS2 and GS5. So effectively what's happened is that countryside stewardship options have been pushed down into SFI for low input grassland. So you could have been in these schemes, these options before, but they are now available in SFI, which is easier to enter. And there will also be a common supplement of £6.15 a hectare available within the SFI. There are additional requirements, mandatory guidance for commons, which we have covered in a previous webinar. It's about having internal agreements, making sure you consult people before you go into the scheme, and also that all the people with legal interest, and also make sure you have a suitable single entity which can hold the scheme. I should say that we are very disappointed that the way that payments are going to be made is still using income foregone plus costs. We feel that if it's public money for environmental goods and services, everyone should be paid according to the value of the goods and services they're provided. The value of biodiversity isn't lower in the uplands than it is in the lowlands, and we do feel it's a great shame that we're effectively pegging payment rates according to what profit you may or may not make on your agricultural activity. There'd be no further
Julia, sorry to interrupt a second. You just let you know you're sharing your speaker notes. If you want to press switch displays or use slideshow mode, top left there, then that should sort that out.
Okay, I'm just going to end that. Hang on a moment. Apologies. That's display mode. Swap. Okay. No.
Yeah, that's it. That's good.
Okay, excellent. Thank you very much, Joe. Sorry about that, everybody. So there are no further announcements for the moorland. We do expect to hear about the intermediate and advanced standards for moorland by the summer, but we also do expect those to be a bit like with the low input grassland, that the countryside stewardship options for moorland maintenance and restoration will be put into the SFI. What's the significant thing about this is that if your land in your common is already in a grassland standard, you will not be able to add in sustainable farming incentive because you can't be paid for the same thing twice. This is, it's disappointing that we haven't yet got additional options you can do, that there's effectively a clash, and it means that if you're already in countryside stewardship, there isn't on a grassland standard on your common, you won't be able to add in an SFI option on top of that. We haven't got the full details yet of where which options are compatible with what, but it is highly likely if you are already in a grassland standard or a heathland standard on your common in the lowlands, you won't be able to add in SFI. The SFI lasts for 3 years. Just moving on to countryside stewardship, here we have the existing 250 options, and there are 30 new options, and there are another good change is that you have 3 years to do capital works instead of having 2 years. There are new payment rates which were released on the 1st of just at the beginning of January 2023. They will apply to all agreements from the 1st of January, with existing agreements and for new agreements. But unfortunately, as I say, they're still based on income foregone plus costs. Defra are, though, exploring additional payments for payments by results, i.e. delivering more and better, and also additional payments for local join-up. That is where you join a number of schemes together. And we think this might be particularly pertinent for commons in the future. But we're, again, waiting for more details of this. The landscape recovery scheme is the 3rd tier, and the announcement last Thursday was that there will be 25 new landscape projects that will receive development funding in 2023. This will be a competitive process. It was highly oversubscribed in 2022. The priorities for 2023 are net zero, protected sites and habitat creation. Well, we know that over half of commons are protected sites, are SSSIs, and therefore they should stand a very good chance of being accepted there. And Defra are keen that commons come into landscape recovery, which is exactly why we're running this test of trial. In terms of the payment rates for delivery, so the way that the landscape recovery works is you get a payment for developing your scheme, and then you also get the actual payment for delivery, and that's likely to be a 30-year scheme, and those will be negotiated on a case-by-case basis, but are likely to have reference to the countryside stewardship rate. So again, still based on income foregone. So the summary really in terms of this policy update is that there is a lot that is being that's changing at the moment. People might say not enough, not fast enough. We feel that the Foundation for Common Land has put out a press release around this. We do feel that it's going to be very difficult for commons who already maxed out on countryside stewardship to be able to get more money out of the system as things stand at the moment. In the future, maybe, but as things stand, your basic payment on your common is declining and will have disappeared by 2028. But if you're already in countryside stewardship on that land parcel, it's going to be difficult to add in more options, particularly if you're in a higher level of stewardship that you can't change. But if you're not in a scheme, do explore countryside stewardship. It's usually the best option for commons because you need to have detailed negotiations around it. But alternatively, you will be able to go into SFI, low input grassland, or SFI moorland introductory standard. So do look at both of those. Now, the theme for this evening is really about governance. This is becoming increasingly important, and we've got a lot of money that is going to be targeted towards commons, but towards commons associations. With basic payment going, each commoner received their basic payment scheme into their own, directly to their own bank account. But now any money that's available will be going to the association, or the whichever single entity is holding the agreement. And so it's absolutely critical that the governance is strong and can deal with breaches. Everyone's clear about what their obligations are and what payments they'll receive. So this provides a perfect moment for me to hand on to Josie Edwards. Michelmores are one of the top-notch firms of solicitors working in this area. They've been assisting a number of the landscape recovery, successful applicants for landscape recovery in 2022, and also work with a lot of landowners and farmers around agricultural and environmental management. So they were a sort of go-to firm for the Foundation for Common Land, and Josie Edwards has been working together with her colleague Ben Sharples on this matter, and we're delighted, Josie, you've been able to join us this evening.
Many thanks, Julia, and evening, everybody. I'm delighted to be here. I will shortly share my screen. that right? Julia, can you see my slides?
Yes, I can. That looks great. Thanks, Josie.
Great. Okay. Many thanks, Julia, for the introduction. As she's already mentioned, I'm a solicitor at Michelmores. I've been a specialist agriculture solicitor since qualifying in 2010, and we've got a large team who have worked in the sector for a long time, but we are increasingly doing an awful lot of work focused on natural capital and the long-term management of land for environmental gains. And we're seeing particularly an increasing amount of instructions at the moment focused on biodiversity net gain, nutrient neutrality. But as Julia said, we've also been involved in some of the landscape recovery scheme test and trial projects. And we were really delighted to be asked to work on this one because not only does it give us an opportunity to advise at an early stage on these sort of complex issues that you face when you're trying to deal with things at a landscape scale, but also the element of common land and ensuring that the arrangements reflect the rights of commoners over that land is a really sort of key and tricky point to consider. So our focus was all about legal governance, how you structure these really ambitious long-term agreements. The anticipation is that they will be a 30-year term. They're going to involve multiple stakeholders across landscapes. So what legal documentation do we need to facilitate effective collaboration at that sort of scale? And crucially, how do you safeguard the investments that have been made in land use change over that period of time and in the environmental outcomes that everybody is aiming for? And given the period, the fact that we're talking about a 30-year minimum term, how do you make sure that they're responsive to the sort of inevitable changes that are likely to happen over the term of these schemes, whether they be environmental changes, changes in the stakeholders involved? We see conservation covenants as a really key tool in the delivery here, and I'll consider them in a bit more detail shortly. Julia has asked me to talk through one of the 2 case studies we were asked to consider for the test and trial project. So for that project, we focused on the New Forest and also on the Malvern Hills. Today, we're going to talk about the Malvern Hills. I haven't got a huge amount of time, so we wanted to focus on one and to sort of work it around a case study to bring it to life a bit, but it will still be quite a high level summary, but hopefully it will give you a flavour of some of the issues. So our recommended structure is set out on the slide here that hopefully you can all see. Broadly, we anticipate a core arrangement which would be entered into with Defra or Natural England, whoever is administering the landscape recovery scheme. And then that lead agreement would be underpinned by at least 2 supplemental agreements which would serve an important purpose in the overall structure. It's those agreements that will make sure that all of the contractual and property rights and obligations are properly accounted for. Now, if appropriate, we see no reason why private funding or green finance could feed into that core structure. That would probably be documented by way of separate agreements and private funders, that there's scope within the structure to blend finance or for private finance to move in separately. And at this stage, we are anticipating that private funding is going to be required to ensure that these landscape recovery schemes are fully funded. It looks unlikely that public funding is going to be sufficient on its own, and Defra are giving clear indications that the landscape recovery schemes are going to have to rely on private finance to a degree. So there's an anticipation that we will be looking at blended finances as we refer to it. But we also think that there is likely to be additional separate opportunities in the private sector, perhaps in the context of nutrient neutrality or biodiversity or woodland creation. And the structure that we're proposing would allow stakeholders to potentially exploit those additional opportunities, subject, of course, to the final scheme rules or the terms of the agreement that's entered into in terms of the landscape recovery scheme. And one thing I just want to keep everyone to keep in mind throughout my talk tonight is this is very much a proposal. It's an early stage proposal. It's our suggestion of one way that these could be structured. And we think that there's significant scope for flexibility in the structure we're proposing to reflect individual circumstances. So tonight I'll use Malvern Hills as a case study, but this could fit any number of commons around the country, and it could also be tweaked or simplified scaled up, scaled down to fit the situation and the sort of scale of the schemes that are proposed, the numbers of stakeholders involved, etc. So just looking at the documents on that slide in a bit more detail. So the first, this landscape recovery agreement, which we're calling the lead agreement, and this is the main contractual basis for the scheme and the funding that would flow under it. And we were anticipating that the signatories would be Defra or Natural England, which as the department administering the scheme, and then a single entity representing the scheme participants, so the Malvern Hills participants in our example, and we'll call that the principal signatory. Now, the lead agreement would then annex and refer to the subsidiary documents, and those will ensure that the various elements and all of the interested parties and stakeholders are contractually bound to deliver the scheme, although they're not direct signatories to the lead agreement. Structuring it this way allows the government to contract with one single entity and it focuses management control and responsibility on that single entity. But of course, they need to be representative of all of the stakeholders involved here. So unpicking that a bit more in terms of the principal signatory, in the Malverns, our initial thought had been that the Malvern Hills Trust would be quite well placed to act as the principal signatory. It had the status and resources to fulfill the role of the primary contracted party. It's got existing relationships with key stakeholders, including, of course, the commoners and the commoners associations. But on a bit of digging, we felt that the charitable status of the Malvern Hills Trust could cause some complications, because if a future scheme is dependent on or receives private finance alongside public money, there's a scope that funding could mean that the Malvern Hills Trust would be deemed to be undertaking trading activities, which could cause problems from a charitable or charity law point of view, which is why a lot of charities end up having trading subsidiaries, so I understand. And so in the context of this case study, and also we anticipate in many instances, if not most, we're recommending an SPV as something that should be considered. So a special purpose vehicle, a new corporate entity to act as the principal signatory. And so just to put a bit of background context there, SPVs are legal entities created solely for a particular purpose. So that might be the financing of a specific project. And their operations are restricted to the limited purpose for which they're created. Now, they can use any legal structure. Private limited companies or limited liability partnerships are commonly used. We also considered the potential for using a community interest company in this context. Now, they are also limited liability companies, but they're designed specifically for social enterprises that want to use their profits and assets for the public good. And their primary purpose is to benefit a specific community and not the company's shareholders, directors, or employees. Now, the regulatory regime around community interest companies is more restrictive, but we felt it's definitely an option worth considering in the context of these landscape schemes. But whatever legal vehicle is used for the SPV, the structure would enable a joint venture enterprise to be set up between a number of interested parties or stakeholders. And we think that that will be attractive in the context of landscape schemes where no one party at the outset has overall management or ownership control. And so all those holding ownership of the land involved or common rights over the land that would be subject to the scheme could acquire shares and therefore voting rights in the SPV. And that share allocation could be reflective of freehold ownership or perhaps the number of rights of common held. And then directorships could be focused on key stakeholders, so those who are willing and able to take on responsibility for the overall administration of the scheme, and they would then have a say at board level. And day-to-day management responsibility could perhaps be delegated to appointed staff member or members. So just to summarise, we think SPVs offer excellent scope to create a recognisable, trusted, legally sound entity that would manage the funding and the liabilities that flow under the scheme, and in that sort of limited liability structure would protect the participants. And the funding is likely to be significant. As Julia said, we don't have a huge amount of detail on the payments yet, but we are talking about 30-year schemes at a scale that hasn't been done before. The limited company structure also provides flexibility if, as is likely, there are any future changes in ownership or the stakeholders involved. You can deal with that via share transfers, change in directors, etc. And the SPV, as I said, would be the controlling entity. They would direct management and enforcement, and the SPV would be the conduit for the money that's payable under the scheme. So underpinning this lead agreement then would be either a single or a multiple conservation covenants, and it is the conservation covenant that will secure the management of the subject land under the scheme for the agreed term. Now, legally, conservation covenants can be for any duration. They can be completely indefinite, but you can choose how long they last for. So in this context, we're anticipating 30 years. Conservation covenants bind successors in title from a legal perspective, and they will run with the land. So in the quite likely event that some land may be sold during the term, or perhaps there might be changes in occupation in terms of tenancies or graziers, any leases or agreements granted after the conservation covenant is put in place would be bound by the conservation covenant and would be subject to its terms. And so the key point here, and the reason that we see conservation covenants as being so key, is that they provide a really efficient, neat legal mechanism to properly bind the land under the scheme for the long term that we are talking about. And we're talking about much longer terms than those we're currently used to under HLS or countryside stewardship schemes. The landscape recovery schemes are intended to be ambitious and to hopefully deliver long-term lasting environmental change. And so conservation covenants, we think, will play a really key role. They've been created by Part 7 of the Environment Act. They formally became effective and on the statute book from the 30th of September 2022, and Part 7 contains a standalone code which provides, or should provide, all the tools required to create and thereafter monitor and enforce, and if required modify or discharge the covenants and the terms imposed on the subject land under any landscape recovery scheme. So the definition of what a conservation covenant is set out on my next slide. That's the definition from the Environment Act. So just pulling out some key points here. It's a private voluntary agreement. It is entered into between private entities and individuals, and it is entirely voluntary. Nobody's going to force anybody to enter into a conservation covenant. It concerns an identified area of land, and that's key. You need to be able to be clear on exactly what land would be bound by the conservation covenant, and it must deliver a conservation purpose for the public good. And we think that conservation covenants will give confidence to the funders behind the scheme, whether that be a government department, private finance, that the scheme delivery is going to be secure for the term agreed at the outset. So it will avoid a situation where landowners drop out of the scheme during the agreed term, which could jeopardise the whole arrangement. And the conservation covenant would, we anticipate, annex a management agreement, providing detail of what the landowner is committing to do over the agreed term. In terms of the parties to the conservation covenant, the Environment Act requires that the covenantor has a qualifying estate in land. So that's defined as either a freehold owner or a tenant holding a leasehold estate for a term of more than 7 years. So going back to our case study in the Malverns, the Malvern Hills Trust is the key freehold owner there, and would have the legal standing to enter into a conservation covenant. But in addition, any other adjoining freehold landowners who wish to join the scheme could enter into a conservation covenant as well. In terms of commoners and the legal rights that the commoners hold, we don't think that you would have legal standing to enter into a conservation covenant. A right of common from a legal perspective is a form of profit apprender, not a freehold or a leasehold estate. And so in our view, we don't think that's sufficient for the purposes of the Environment Act to be a qualifying estate, and that it will only be the freehold owners who will be able to enter into a conservation covenant, or in different landscapes, perhaps long-term tenants. But conservation covenants can clearly be created in relation to common land, but of course, as Lyndsey alluded to at the start, they will be subject to the registered common rights that affect that land. And all of those common rights will have to be considered before the covenant is entered into, and the covenant terms must be compatible with those rights. Landowners are going to have to be confident that they can comply with the terms of the conservation covenant, and its delivery won't be jeopardised by the commons rights, which is something I'll consider in a bit more detail below. And likewise, all of the existing statutory designations or protections, whether that be AONB, SSSIs, will need to be considered. The terms of the covenant will have to reflect those designations. And the other party to conservation covenants is the responsible body, and it's the responsible body who will ensure that the objectives of the conservation covenants are secured and delivered. They will be responsible for monitoring it. Now, in terms of who the responsible bodies are likely to be under any conservation covenant, it could potentially be the secretary, although it's obviously likely that that power will be delegated. And the Secretary of State can also designate bodies under section, and will designate other bodies to be responsible bodies under section 119 of the Environment Act. So it's clear from section 119 that local authorities can be responsible bodies, but also other public bodies or charities or private entities, provided that they have mainly conservation related functions or purposes or activities. So the definition encompasses certain for-profit companies, provided they have that conservation focus. Organisations will have to apply to be designated. They will have to decide whether they feel they have the capacity to perform the functions of a responsible body. And we know that the Secretary of State is going to determine the criteria to be applied, and the applications will then be assessed by reference to those criteria. Now, really frustratingly, although Part 7 of the Environment Act came into force in September, we still don't have any details around the appointment of responsible bodies. We're still waiting for Defra to release those. And so it's still TBC whether there's going to be further qualifying requirements on top of those listed in section 119, and what the application and registration process is going to be. The latest update is that it's due in early 2023, but we're still waiting on it at the moment. So we're in a slightly weird limbo situation where in theory you can enter into conservation covenants, but actually you can't enter into them with a properly appointed responsible body. Now, going back to our case study, the Malvern Hills Trust would appear to satisfy the section 119 requirements for a responsible body. It was set up by an Act of Parliament. Its charitable purposes specifically focus on managing the land it owns for the conservation of wildlife and the enjoyment of the public. But in circumstances where the Malvern Hills Trust is also a freehold owner, and so it would both own and manage the subject land, we concluded that it was going to be unlikely that it would be appropriate for it to take on the responsible body role as well. It would be in a position of wearing both hats. And we anticipate that that might follow in Defra guidance. One cannot police oneself. And in any event, we consider that those sort of controlling the finance and deciding whether to invest and support a scheme wouldn't be comfortable with a freehold owner also being a responsible body. But there are a number of alternative bodies that should be very well placed to fulfil the responsible body role in the Malverns in our case study example, assuming that they wanted to do it. So Defra, Natural England, perhaps the Malvern Hills AONB, or in other scenarios, perhaps the local county council would be relevant. And then finally, moving on to the third document, which is a crucial part of the contractual pyramid. This is the management agreement, and it's under this agreement that the allocation of the funding, the obligations and liabilities will be divided up between all of the stakeholders. So it's in this document that the detail will appear, including who will be paid for what and how much. And we anticipate that in some circumstances, there may be multiple management agreements. And now the active commoners in the Malverns would deliver some of the management obligations we anticipate, and they will therefore, of course, be parties to this agreement alongside the freehold owners and any other stakeholders who might assist with the capital works or management. So again, perhaps the AONB may be involved in that context. So the parties to the management agreement won't be limited to landowners. It would contain detailed provisions dealing with default, breach, penalties, etc. And we anticipate that indemnities would be given between the signatories to the landscape recovery scheme to ensure that any losses suffered by the wider group in the event of a breach by one party would be underwritten and reimbursed by that defaulting party. And we think it should be possible for there to be some ring fencing of the scheme budget, perhaps. So certain aspects of the scheme could be ring fenced to particular participants. So you could have separate funding pots, ensuring that they aren't jeopardised by the breach of a more remote or less closely linked part of the scheme. If there's a breach in one aspect, that it doesn't jeopardise others. So just focusing a little bit more about the position of commoners in these landscape schemes. In the Malverns, our understanding is there is a relatively small number of active commoners in the Malvern Hills, and that some, if not all of them, have been involved in the various higher level stewardship and countryside stewardship agreements to date. And so we're anticipating that those active commoners would be included in the scheme if they wanted to be included, because the scheme and the underlying conservation covenants will have to take account of their pre-existing commons rights and to be consistent with them. So their involvement is a prerequisite. And in addition, no doubt some of the grazing management required under the scheme would be delivered by or in partnership with the active commoners. We don't know at the moment whether management will be radically different under these sorts of schemes from the current management on commons, and we don't know the extent to which the management proposed will be consistent or not with commoners. Requires management which restricts or limits commoners' rights in any way, then it's obviously going to be vital that active commoners sign up to it and are contributing parties. Non-active commoners are obviously much more difficult, particularly in circumstances where the scheme might seek to limit or control how they exercise their rights in future. And I think it's going to be really key to ensure that any funding or money flowing under these schemes is attractive to everyone and attractive to commoners. There have got to be benefits for everybody to get involved, and we need to ensure that the money filters down to all of the right places. It needs to be something that people want to be involved with on a number of fronts, the environmental reasons and also financial. And as Julia alluded to, the landscape recovery scheme hopefully has scope to replace the lost BPS income and to build on the money available under countryside stewardship. So whilst the position of non-active commoners in particular is potentially a bit more problematic, we don't think it's insurmountable, and we hope that could be resolved and clear that it can be. So finally, as I mentioned at the start, if there's scope to obtain private finance, either to enable the delivery of the landscape recovery scheme itself or for entirely separate environmental benefits outside of the scheme, we feel it can be incorporated into this structure we're proposing. And we anticipate that separate contractual and funding agreements would be entered into with the private finance companies. The terms agreed would obviously need to be fully consistent with the landscape recovery scheme that's signed up to and its rules and the underlying conservation covenants and management agreements. It's another reason we think that using an FPV to fulfill the role of a primary signatory under the lead agreement is a good idea, because it will allow for greater flexibility to obtain private finance. It's a legal structure, an entity that they are used to dealing with. And in our experience, if private investors become involved in these funding anything, not just these schemes, it's likely that they will want something in return for their investment in terms of management control. So, for example, you often see them requesting a shareholding in the controlling entity. That's, of course, obviously subject to negotiation and will depend on the commercial realities at the time. But the SPV structure provides potential for flexibility and diversification into other income streams without it being an overly complex or difficult structure. It's essentially a really simple model, and it's well understood. And we think that using that and then underpinning it with the right contractual and land-based agreements will work well. So just concluding and summing up, we are really confident that an appropriate legal structure can be designed to deliver these schemes at landscape scale and to protect the rights and obligations of all interested parties and the scheme aims and objectives. while some aspects of it will be complex, particularly in the early years of these new schemes, the rewards for land managers and owners collaborating at a landscape scale should be significant for the environment and financially. And although it being complex, it's likely to also be quite costly to set up. You do have to think about those transaction costs over the period of 30 years. And some of the environmental outcomes and improvements delivered under these schemes will hopefully extend well beyond that sort of time frame. And so we think that we can balance the challenges and the costs with the opportunities here. And it's an opportunity that we should all grasp. I've got on my slide to stop for questions, but I know that there's a Q&A session at the end, and there's a talk now from Jo and Sue. So I will hand over. Many thanks.
Thank you so much, Josie. That was absolutely great. I know it generated a lot of interest, and in particular, people understanding the different legal structures, the structure of the conservation covenant and then the management agreement, making sure that people understand those two different documents, isn't it? So that it's not that commoners are excluded, they're very much included. It's a matter of within which document, isn't it? So I think when people will come onto that, and that's something that there are various questions that are being asked about. So perhaps while I've read no rest on this webinar, Josie, but if you were able to have a look at the Q&A and get yourself teed up while we move on to Sue and Jo. And people who've attended our previous webinars will have met and seen Sue and Jo, Sue Mitchell and Jolie Per before, and we're absolutely delighted to have them back with us. Sue's based in the New Forest and is going to update us on what's been happening so far in terms of both projects. And so, Sue, over to you.
Hi, good evening, everybody. Just to say again, thank you very much to Josie for that very comprehensive talk through the work that Michelmores has been doing. I am just going to show you a little bit about what we have found with our key findings in this phase 2. So I'm just going to share my screen with you, share that, and here we are. So we can start. Okay, so I'm hoping that you can see the right screen there. As Julia said, I'm the facilitator for the New Forest, and my colleague Jo will be talking to you in a minute, and he's the facilitator for the Malvern Hills. So here we're looking at this is phase 2, and the question that we are asking in phase 2 is about how to construct agreements for different land ownership structures, and we're looking specifically at common land. Commons, as I'm sure you're aware, is far more complex than a lot of other land ownership structures, because we have the property rights that are held by both the landowners and the commons, and Josie has talked to you at length about that and some of the hurdles that have to be jumped there. In the test and trial, we've been using the New Forest and the Malverns as our examples of lowland commons, and they have quite different governance structures. And so it's been interesting to see how they've been working and how things may change. And Josie has talked you through the Malverns example. But we have had workshops and meetings with the key stakeholders in both landscapes throughout phase 2. And Michelmores was commissioned in the summer to examine these theoretical legal structures and governance for the long-term agreements for both the New Forest and the Malvern Hills. And then sort of in November, end of November, beginning of December, Michelmores gave their presentation of the findings and the advice that they would give to the key stakeholders. And since then, we've been gathering feedback from the stakeholders, and we're going to respond to that as well. So as part of our test and trial, we've come up with about 2 main key findings. And they focus on private finance and scheme payments. And then the second one that we're going to have a little look at is about the governance and legal structure. So this is what has come back to us that we feed back to Defra. So with private finance, it's been discussed, but there is this thing of the statutory duty of public authorities with regards to the designations such as the SSSIs may make private finance incompatible. This is due to the section 40 of the NERC duties, and it's really about sort of the duty to maintain and enhance the biodiversity and the species. So there is a little bit of question, and we feel this may be particularly pertinent to common land, as 50% of it is designated as SSSI, and a lot of common land, not all, but a lot of common land is owned by statutory bodies. So there's some, some hurdles to get through there, and that's been raised quite a bit. And also in scheme payments, commons are very different, very diverse places within commons. They're very different too. There might be different outcomes that are being sought, and bespoke payment is something that came up in phase 1 and has materialised again in phase 2, and looking to create these payment schemes, looking, sort of representing the different rates that incentivise specific outcomes that we're looking for in landscape recovery, or the CS Plus or the countryside stewardship, that second level, rather than some of the inconsistent application of rules that we have seen. So again, we're coming out of CAP, we're going into these new realms, and we've got an opportunity to look to see what is going to give us that sort of robust agreements going forwards. Then the last key finding that we've come to look at is about governance and legal structure. Here we're looking at the fact that complex, large-scale landscapes, sort of a big mosaic of landscapes which have been locally created, sort of managed through different schemes, some CS schemes, some HLS schemes. Sometimes bringing all these schemes together may be counterproductive, and they may not always be attractive to private finance. They might look a little bit unwieldy. There might be a question of ethics about people wanting to accept private finance from different areas, and also sometimes maybe a sensation that it could all be a little bit overwhelming when people have been doing things, or maybe on a smaller scale, suddenly to be in part of a big scale might be counterproductive. And there's a feeling that's coming back that maybe a number of independent CS schemes from landowners could be more beneficial and actually provide better value for money than the one large landscape recovery scheme in landscapes such as the Malvern Hills and the New Forest, especially if there's an opportunity, which has been mentioned also here before, for extra payment for specific cooperative and cross-boundary projects. So the jury's still very much out about, is it going to be landscape recovery or is it going to be CS schemes? What's going to work? There's a lot to work through to look to see where people want to go. Although most statutory bodies and publicly funded organisations are keen on the concept of conservation covenants because it ties in things, there's still a lot of uncertainty. Common land is for the most part highly designated, SSI, SAC, SPA, Ramsar. What does a conservation covenant add to very regulated landscapes? And then that because they're long term, 30 years, private landowners of common land and non-common land that is adjacent to the common, which might be used for in-by land, for backup land, regard conservation covenants as a barrier to landscape recovery schemes due to the potential devaluation of their land and the narrowing of their future land use. So there's still a lot of conversation going on, a lot of feedback coming, and questions being, as usual, more questions probably being raised than answers at the moment. So I think that's probably key findings from me, and I'm going to hand you over to Jo, who's going to just quickly run through what we will be looking for in phase 3. So thank you very much, everyone, for listening.
Thanks, Sue. Just check you can hear me all right.
Yes, we can hear you, Jo.
Good. Okay, thanks, Sue. As Sue mentioned, I'm Jo Leaper. I'm a test and trial facilitator, Sue's counterpart here in the Malvern Hills area. So I'm just going to give you a very quick overview of where we're at with the test and trial project as a whole and what we're going to be doing for the next phase of the project. So quickly just going over the project timeline as a whole. We started the project in March 2022, running through to June 2023. Phase 1, which we already completed, was looking at incentives to join landscape recovery scheme in both areas, the New Forest and the Malvern Hills. That's already been completed, and we ran a webinar on that previously, which you can, I think Lyndsey mentioned earlier, you can check out on our YouTube channel. I think there should be a link on the website as well. And you've just heard plenty on this, which is phase 2 of the project, which we've been looking at governance and payment mechanisms. And we've got the third phase of the project to go to next, which we have already touched on some of with the conservation covenant with Michelmores, but we're going to be looking at more detail on that in the next phase of the project. So what does that look like for phase 3? The question we're answering, or what we're looking at here, is how to construct long-term agreements, so 30+ year agreements, which you've heard some about already. And we've heard how important robust governance is on commons. So the next phase, we're going to be looking in more detail at things like conservation covenants and really digging into how that might work on commons, what the barriers might be in more detail, and what kind of legal structures might come into, and how we can safeguard, if there are any other options for safeguarding investment from government and private finance in the long term. So yeah, as I mentioned earlier, this phase of the project, phase 3, is running from February, basically now, until June 2023, later this year. And in terms of the outputs for this phase of the project, we're going to be running a number of workshops again, with our meetings with our key stakeholders from each of the landscapes, the Malvern Hills and the New Forest, looking at these long-term agreements, talking in more detail about them. And yeah, so from those, as we similar to the other phases, we're going to take the data, analyze what we've from our conversations, key learning points, key findings, and feed this into another report for Defra, which will be our phase 3 interim report. From all of this learning, we will then be doing a final test and trial report for Defra, which will bring together all 3 phases of the project. And we'll also be releasing some sort of version of that more public to the wider public as well. We'll be delivering a final webinar in June, so look out for that. And you can there'll be more information coming your way if you've signed up to our mailing list on that, and also on our website nearer the time. And we'll also be adding all our learning on this landscape recovery test and trial to our FCL Commons toolkit. So if you're thinking of in the future setting up a landscape recovery scheme and you want to know what you need in place to do that, we're going to put all this learning up on our website as part of our toolkit, so you'll be able to access that there in the future. Okay, that's just a very quick overview of what's coming next and what you can expect in the future from us in this test and trial. I'm going to hand back to Lyndsey and I think Julia and Josie for the Q&A now.
Sorry, Joe, I was muted. Thank you so much for that presentation. We have had lots of questions in the chat relating to our next phase, and we will have a follow-up webinar in the summer. So we have a little time now for some questions. We'll start with a question for Julia from Janet Dwyer, and she's asked, has Defra confirmed your understanding that you can't stack the SFI grassland and countryside stewardship GS5?
Yes, they have. So I've asked this directly to Janet Hughes. If you look at the document round that was produced last Thursday, it's very clear that landscape recovery Lowland grassland is a variant of GS2 and GS5. So there is no ability to stack those two together. So that's a huge shame. So yes, that's where we are. And there are various other questions, aren't there, about stacking? I don't know whether we want to answer a few of these at the same time, Lyndsey, or things like salt marsh and
Yes, so would you be able to answer that one, Julia?
Yeah, so I think the key is if you look at look on the Countryside Stewardship at the website at the moment, and you see that if it's a land management action, an option that's covering your whole field parcel, you can see there what supplements and what things you can stack there at the moment. It's very unlikely you're going to be able to stack something such as GS2 with salt marsh, because it's either under salt marsh option or it's going to be under a low input grassland option, and so you wouldn't be paid for those at the same time. That means you won't be paid for having them in SFI and in Countryside Stewardship. There are other questions saying, really, how do we access our lost BPS funds? If we would like to do more for nature, more for climate, how do we do that as things stand at the moment? And as things stand at the moment, you can't. And that's why the Foundation for Common Land put out its press release to say how disappointed we were that those people already, have been doing good things for nature and for climate are being disadvantaged by they'll be losing their BPS and won't be able to, there aren't any options for them to do more as things stand under their current agreements.
Thanks, Julia. We've got a question in the chat from Rachel Thompson. There is a huge opportunity to incentivise green infrastructure creation and improvement in elms. Public access space can often be enhanced for nature and biodiversity and safeguarded for the future. What are you planning to increase public access creation and improvement opportunities for all non-vehicular users on common land? So I think we've had lots of questions on access, and there is clearly some concern that access is not being given the priority it needs on common land. And what your thoughts are on that, Julia?
Well, I would totally agree that when we had the original 6 baskets of public goods in Health and Harmony 5 years ago, public access was very much there. At the moment, what we're seeing is that the only options are those that are currently available under Countryside Stewardship, which are around educational access, which is absolutely critical, but in itself isn't sufficient. We do need to remember that commons have open access, so there's a statutory right of access across these areas, and so that, but we do know that public access benefits enormously when it's well managed, and the whole issues that have come up in Dartmoor recently often have arisen out of frustration around poor management of access. And Lyndsey, you will know in the New Forest how challenging sometimes public access is. Unfortunately, so far there aren't additional payments for that, but that means that this may be an area where landscape recovery would be really suitable, because if you have landscape recovery, what people are saying, why enter a landscape recovery? Well, if management of public access is central to your common, then that can be built into your bespoke agreement, and I would suggest that's a really good reason to look at landscape recovery, and that Countryside Stewardship can't do everything. But that's why it's good to have a landscape recovery option, and that would be an opportunity to build in effective management, the capital works that are necessary for that.
Thanks, Julia. Josie, would you, and we've had quite a few questions on conservation covenants and also on the difference between Countryside Stewardship agreements and a landscape recovery scheme. I wonder if you could, first of all, explain how you see the difference between Countryside Stewardship agreements and a landscape recovery.
Thanks, Lyndsey. So one of the key things is that landscape recovery scheme is intended to be more ambitious, both in terms of the duration of those schemes. We're talking about 30 years, not perhaps 5 to 10, and also the number of landowners or stakeholders who wish to collaborate and come together. And it might be that in some circumstances, it is more appropriate to continue to have a network of adjoining countryside stewardship schemes that do reflect one another in some ways, but are separate, standalone. But for the more ambitious schemes aiming to make big changes in terms of the environmental outcomes, we think landscape recovery, that's where they will come in. But both options are, perfectly valid, and both are there to fit the particular circumstances once we know more about them and they start to come live.
Thank you. And moving on from that, Julia, Matt Gardner's given us a really good question. He said, if landscape recovery payment rates will likely be similar to countryside stewardship rates, what possible reason would landowners have for entering into one? So it's similar to the question that Josie has answered, but I wonder what your perspective would be.
Really good question, Matthew, and I've been reflecting on this since you've written it. I think there are several reasons. It's all a matter of what's appropriate for your context. As Sue has said so clearly, commons vary enormously, and what might be right for one common might not be right for another common. So there are various things that countryside stewardship schemes on commons generally have been for 10 years. But if you want to do something significant that's going to be, as Josie said, significant land use change or capital works that are going to take time to take effect, for instance, some tree planting or scrub management or long-term peatland restoration, then you may well want to commit for 30 years. We know commons have been there for many centuries, and actually 30 years isn't that long, particularly if the landscape recovery can build in some review periods. So I think knowing where you are for sort of 30 years, it may be an advantage to some. To other people, they may see it as a disadvantage. The other thing is around the bespoke nature. So countryside stewardship is, you would end up putting together a mixture of different options, and it may be not appropriate, and the options may not be appropriate to your particular circumstance, and there will be rules about what can go with what. While if you put together a landscape recovery scheme and you have a coherent plan with a coherent, you're putting together a bid, then it will make it more attractive. It's a holistic systems approach to your common, rather than trying to mesh together various options that don't really work. The other area is around the conservation covenants, and there may be opportunities for bringing in private finance as well as public finance, and then by having one vehicle and one scheme, because a lot of people looking at companies wanting to invest will be looking at a 30-year commitment rather than a 10-year commitment. So that's another area, or they maybe even be looking for longer. But if you only have a 10-year stewardship scheme, you may be nervous about taking on a 30-year commitment for carbon credits or for biodiversity, net gain, etc. But Josie may wish to chip in with some additional thoughts on this.
I was just going to make the point that you made about the financial side and the private finance, Julia, and I think as we've both alluded to before, Defra are indicating that these landscape schemes are going to be funded by a mix of public and private funds. So although the money available for Defra, the indications are that might not be much better than countryside stewardship, we're anticipating that it could be topped up in some cases quite significantly by private investors who want to get involved in the package that people are proposing for their particular landscapes. And as you say, Julia, they can be entirely bespoke, and they can focus particularly on the things that you as stakeholders want to achieve and want to collaborate on, and need funds to allow you to invest in that to deliver that environmental change.
I know that we've talked about this, Josie, when we met. We've got a question here from Charlotte saying, why would you have a conservation covenant on SSSI common land when it has so many legal protections already? And I know that relates to the private finance question.
Yeah, so I think one of the key things is that predominantly the existing protections like SSSI, etc., are trying to protect the landscapes as they are now. My understanding is that these landscape recovery schemes are going to be aiming to improve the landscape and to achieve additional conservation or environmental outcomes. So we are doing something more ambitious than protecting the current status quo. Conservation covenants will have to take account of SSSI designations, all other statutory designations, and of course everybody's rights over those lands, crucially including commoners' rights. They will have to be, the schemes that are designed will have to be consistent with the rights that commoners hold. But it's a different thing building on top of the existing designations is our understanding of the ambition here for landscape schemes. And we're trying to give confidence to whoever is investing in those schemes that that investment will be protected for the agreed term. And I noticed one of the other questions that was, what happens after 30 years and the covenant ends? does the land, what position is the landowner left in then? Well, the key thing is that they will obviously be left with the habitat that has been created. They will be free to then do what they can with that. But it's a decision at the outset of this as to what you are willing to commit to do on the land that you have control over, not just for 30 years, but for the long term thereafter, because you need to be aware of what you're going to be left with at the end of the term, obviously.
And Josie, whilst you're there, would you mind just explaining a little bit more the difference and the importance of both the Conservation Covenant and the Management Agreement?
Yeah, so the Conservation Covenant, as I say, is just one element, because that's the one that the landowners will sign up to commit their land to the scheme and the agreed outcomes and the agreed management over the term. And that's the legal document that will ensure that that land, the area identified, is properly bound by the scheme terms and protected for the agreed duration of the agreement. But the management agreement is where everybody who is involved with the land, whether they be occupiers, tenants, commoners, landowners, perhaps other bodies who are involved in capital works, they will be involved and signatories to that management agreement, and the funding will flow down through that management agreement and be divvied up. And as I say, in the context of the structure that we had set out, where there would be a new special purpose vehicle at the top, all of those stakeholders and occupiers and interested parties could potentially have a stake in that company as well, and have a say in terms of being on the board or having shares in the company. So it ensures that everybody's voice is heard throughout, and the funding will flow down through the agreements. The Conservation Covenant sort of sits on the side to protect the property rights and to properly bind the land involved.
The question from Chris Short that's been upvoted quite a lot is the issue of liability is a challenge. So would one signator be able to afford liability if they were in breach and jeopardise the whole project? And I know that this jeopardy by individuals is something that's a concern to a lot of people, and certainly we've spoken to people in the Malverns and the New Forest about this.
And I can see why that would be a concern. I totally take the point. It's a really, really good question. It goes back to the point I alluded to in the talk about potentially ring fencing certain aspects of the scheme or certain funding and income streams that flow down it. So if, for example, you're being asked to undertake certain management on one area, that there would be a distinct ring fence pot that thought is going to have to be given to the sort of penalty process that might be imposed if people default on what they have signed up to do. And overall, again, having a limited liability company at the top of it should provide some protection in terms of the overall risk and cost risk. And it will have to be something that everybody negotiates and considers when they decide whether to sign up. And the penalty point might need some further consideration if that is too draconian. It might be a position where you lose the funding that you had, but it's all possible. We really do think it is all possible, and it can be looked at in the detail.
Excellent, thank you. Julia, I just wondered if you'd like to answer the, we've had a few questions about tax, and I wondered if you'd like to talk about that.
Yeah, well, I should caveat this by saying I'm not a tax expert, and Josie would probably say she's not a tax expert either, but it is, it's a complex area, and at the moment, agricultural property relief, so there are a range of tax reliefs that are available on agricultural land that aren't available on land that isn't farmed. So it's important, to take professional advice on this. In terms of most land is still proposing to be be farmed. So you were still planning to have grazing on commons, certainly. If it's something like the New Forest or something like that, then the land is owned by a public body or a charity, then it's not planning to dispose of that and have a liability for inheritance tax anyway. So that shouldn't be an issue. This is perhaps more around private landowners who would be considering this. So in terms of most commons, we would expect some grazing of stock to continue, the land to continue to be farmed. It's always a matter of degree. You know, if you have 10,000 hectares with one cow on it, then the inspector is likely to say, is that got farming or not? There has been a recent guidance issued by Defra and HMRC, and they effectively haven't changed the current law. The other thing that is possible, that there is business property relief available as well as agricultural property relief available, but it is a complex area, and where I would suggest people take advice because it will be very context specific. I don't know, Josie, whether you want to add any more to that.
No, I don't think so. I think that's an excellent answer, Julia.
Moving away from the specifics of the landscape recovery, there are a few questions, Julia, related to your ELBS update. One of the questions that's really moved up is there any prospect of moving away from income foregone? The uplands will be disadvantaged by delivering similar or more benefits as lowland for less reward.
Well, Richard, I couldn't agree more, and I was interviewed by ITV Border on this yesterday. Effectively, where the government committed to levelling up, and we're levelling down with the money flowing from the uplands to East Anglia as things stand. And it's hugely disappointing that those people are already committed to stewardship. And this is the same in some of the lowland areas, such as the New Forest, where they have BPS as a really important component that partners and pairs with their income from stewardship. And similarly, where it's not just an upland lowland area, but it's for areas that are already heavily committed to stewardship, there's very little more that's on offer. So, I mean, we've built this as a bit of a sort of emperor's new clothes. So countryside stewardship has been, we've got pretty much the same options available, and with SFI, a subset of countryside stewardship options being rebranded as SFI. And in terms of moving away from income foregone, we pushed very hard on this, and I know that Therese Coffey's been interviewed on this as well, and that should be coming out, I think, in an interview by Abby Kay, if not today, then in the next 2 or 3 days. And I was told by Defra that income foregone was a bit like democracy; it was the least worst option. I'm afraid I don't buy that, because I think it's lacking an intellectual rigor in terms of my training as an economist. It's also lacking in terms of fairness and equity, and in terms of levelling up rural areas that are delivering most and have the potential to deliver for the green economy. And what this should be an area, if anybody listened to the IMF today, if we listen to the fact that, you know, the UK's economy is going down the tubes, what we do have is the potential to grow our economy. And I think that we ought to be seeing investing in delivering for biodiversity, delivering for climate change, delivering for health and well-being through improved access is absolutely essential. And we are likely to see more farmers and landowners and rural communities going out of business as a result of this. I won't go on any further, but I think you've got the message that we're disappointed. There are reasons put forward around WTO rules and amber boxes, etc. People who know more about this than me will tell you that these are choices that the government has made. There are ways around this, and we have been paying 1.9 billion per year through basic payment, which now, so if we, and that's certainly what people could say, it was a distorting payment. So it's at the moment it's very it's very unfortunate that this is the way forward. We're not actually paying public money for public goods. We're paying public money for people stopping unprofitable livestock farming.
Thanks, Julia. Janet Dwyer's made a similar point. It's more than disappointing. It's just insufficient for all those farmers already in agri-environment schemes whose BPS payments have maintained their business viability and are now disappearing. These are efficient and environmentally friendly farmers, but the prices they get for their products simply don't cover the public value that their management can generate. And in many cases, the agri-environment AEM aren't yet delivering the resources or the learning needed to sustain sensitive and appropriate management. So a similar response. We've got just time for a couple more questions. Susie, would you mind running the polls so that we can finish on time? But we'll keep talking. We've got, just looking through the upvoted questions.
I think the triple SI one.
Oh, sorry, Julia, go ahead.
I was just going to say around the triple SI, because lots of comments are triple SI.
Yeah. So do we know if triple SI Commons will be allowed to enter SFI instead of a CS agreement?
The answer is they should be able to. So I've looked this up, and that they will be eligible to apply, but you'll have to apply for consent separately from Natural England. So RPA are issuing the schemes, the SFI and CS schemes, on behalf of Defra, and Natural England have a statutory duty to protect triple SIs. And that means if your SFI option means that you need consent from Natural England, you will need to apply for that. So you would, and they are developing new schemes where there should be a hub where you can put in almost a sort of template notice for consent, so that will try to streamline that process. But there's no reason why you shouldn't be able to apply, as long as the options are compliant with delivering the features of interest on your site. But you would hope, if you choose the right option, you know, for instance, if you've got a peat bog and you choose within SFI, you know that you're going to be fairly managed. It's not as though you're choosing to plant trees on a peat bog. It's going to be like low input grassland, you would hope will be appropriate. But we are waiting more information. With all the stuff that's come out last week, there will be the detailed guidance that will come out in the springtime. But the big headline is that's actually written in is that yes, you should be able to apply for SFI on triple SIs. The other thing is that they should also get the supplement, the £6.15. So that's another additional incentive there.
A question from Tony Hockley. Although the covenants will be private agreements, will they be published and openly monitored? It would be strange if transparency and local accountability reduced under ELM. Josie, I don't know what your thoughts are on that.
Yeah, another really good question. At the moment, the only indication is that responsible will have to report to the Secretary of State each year to say how many conservation covenants they hold. And I think in addition to that, what land they relate to, but the detail of the covenants won't be published. But again, that's something that we could have a bit more. It's clear that they might issue further regulations in due course if that's something felt is needed. It may be that responsible bodies and the parties involved are quite happy to publish them, and they are published in other ways, not necessarily through a central register administered by the Secretary of State. But it's still TBC, that one. The indications are that not a huge amount of information will be available.
And another one linked to that from Robin Milton. Is the investment protected? Will those buying conservation covenants have to provide the 30-year funding up front or held by the responsible body? Or will it be an annual payment by them with the associated risks of non-payment and business failure? So I think this is related to private finance rather than any government funding.
So I think, again, that will depend on the scheme and depending on exactly what is being created and developed over that 30-year term and when the money needs to flow in, and it might be that it comes in stages as capital works etc. are rolled out or developed. And I'm not anticipating that it will be held by the responsible body. The money won't flow under the conservation covenant in a lot of circumstances. It will be under that lead funding agreement, and the terms will be there, and then the conservation covenant is a legal document relating to the property rights underneath that.
Okay, brilliant. Thank you so much, Josie and Julia. I think we have come to the end of the evening. It's been a really fascinating webinar, and I have to say, from all the webinars that we've done, this has been the most lively chat and Q&A, and it's been quite hard to follow. We will have a record of all these questions, and anything that we haven't been able to answer, if you really would like the answers to your questions, please drop us an email and we will try to find the answer, or we can put those questions into our next phase of our test and trial, and we can answer those with others and share that with Defra. We also will try and answer some of these through our Twitter feed as well. Don't forget, you can listen again to the webinar on our website, and I would really recommend going and having a look at the Commons Toolkit and at the other resources we have on our website. Thank you, huge thank you to the team behind the scenes, so to Susie, to Joe and Susan, who are busy in the background, and a very personal thank you to Julia for the unbelievable amount of work that you do for the benefit of Commons. I know, because I'm always trying to get hold of you, just how hard you work and how busy you are, so a big thank you. Looking at our question, which do you think would work better for Lowland Commons, we've got a choice of landscape recovery, individual countryside stewardship schemes, linked countryside stewardship schemes, and the new countryside stewardship scheme plus, or not enough information. And unsurprisingly, people still feel that there isn't enough information to make decisions going forward. And I know personally, as a farmer and commoner, that uncertainty is extremely damaging. So thank you so much, everyone, for attending. It's been really, really useful. I don't know if Julia, you want any final words?
No, just a huge thank you. Sorry about the slides, but no, it was great to have so much going on. You know, the key is we have options on the table. Do please use them. I know it's not perfect. I know it's not everything we would look for, but ELM is the game in town. There are options there. So please do look at it really carefully and see how you can optimize for your common and your land going forward.
Good night.
Thanks a lot, Lyndsey.